Today we are going to be discussing a very important fundamental right of every single citizen of the United States, and this is the right that is under the Sixth Amendment of the United States Constitution, and that is the right to effective assistance of counsel. And the ultimate question that we're going to be dealing with today is, when do we have that right? Doesn't matter what we're charged with. Doesn't matter what we're facing in terms of a penalty or punishment or fine. Does it really make a difference at all? And really, you can be wondering the question that, wait a minute, didn't you just tell me that this is a right under the Constitution of the United States? This is the very Bill of Rights? So of course we all have this protection of effective assistance of counsel. It says straight out in the Sixth Amendment. So in order to even begin the discussion about effective assistance of counsel on the Sixth Amendment, we have to first understand that there's two separate systems. I may have mentioned this before in some of my other videos. There is the federal system and there is the state system. Federal system has federal statutes, has their own federal court system, and has federal case law, federal opinions, all the way up to the United States Supreme Court. And then there is the state system. The state has their own each state has their own constitution. Each state has their own statutes. Each state has their own court system. And each state has their own opinions. And they have their own Supreme Court. So then we're back to the question of, well, does the Constitution apply to all the states? Or does it only apply to federal statutes, federal laws, federal prosecutions, federal penalties? Does it apply at all to the states? Well, the first place to look is to look at the Constitution to see, is there anything in the Constitution that requires states to do anything? Is there any point in the Constitution where it's saying we are now talking to the states, and states, you all have to listen to what I'm about to say, and this specific amendment will apply to you? That's where you have to look. That's a very obvious place because the Constitution is saying it straight out. But without a clear indication in the Constitution itself that it's specifically talking to the states, well, then the argument could be made that all of the amendments and everything that's said in the Constitution, if it doesn't specifically say what the states have to do or adopt, then it's only in the federal system. And that's where our entrance into this wonderful world of Gideon versus Wainwright begins. That is the landmark case which we're going to be discussing. But also another very important case is the case that preceded Gideon versus Wainwright. Gideon versus Wainwright actually overruled a different case. And the other case was called Betts versus Brady. So first, obviously, we're going to have to get into Betts versus Brady, and then we're going to be discussing Gideon versus Wainwright. But even after all this discussion today, and even though it's going to be very simple and understandable to you, we are still going to be left with a very important question. And that's where I am asking you to help me and help provide me with an answer, because this is the question that I have myself. After reading both of these opinions, I am wondering about a question. And I think it's a decent, valid question to be asked. And that's why I'm asking, and I'm beseeching you, my wonderful subscribers and viewers, and if you haven't yet, please do subscribe and like the video, to please leave a comment, and drop an answer. Help guide me. Maybe there's some case law that I overlooked or I didn't see yet that actually answers this question. Or maybe you can just give me your own opinion about it. So we are going to get to that question after we run through the analysis of these cases. So let's first discuss the Sixth Amendment. What does the Sixth Amendment actually say? Does the Sixth Amendment say anything to the states? Well, this is how the Sixth Amendment reads. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So, right off the bat, I think, and this is just me as a lawyer talking, that I think right off the bat, you can already make an argument that the Sixth Amendment itself already thought, when they wrote this, that they were talking to the states as well. Why? Because it says in all criminal prosecutions. It doesn't just say in federal criminal prosecutions. It says in all criminal prosecutions. You would think encompasses no matter where you're being prosecuted and no matter which laws you're being prosecuted under. But would it surprise you that I didn't see that argument brought up in anywhere? Not in any of the opinions did they discuss this argument. And I think it's pretty decent. You can let me know in the comments whether you think that that's a decent inference to be made from the Sixth Amendment itself. It could have just said in criminal prosecutions, and since it's in the federal system, then obviously it's talking about federal crimes. But the fact that it said in all criminal prosecutions, I can already make an argument, I think, that it would also apply to the states. But, okay, maybe you don't like the argument, and the justices in these two opinions didn't apparently either, or they didn't think about it, or the attorneys didn't bring it up because it wasn't really discussed. But that's just for completeness to bring to your attention that verbiage of the Sixth Amendment. Okay, so nothing in there about the states. Nothing in there about what the states have to actually do, except if you buy my inference. All right, so let's assume that my inference is wrong, because that's what it seems everybody assumed. All right, so what are the states bound by the Sixth Amendment or not? So it would seem that they're not, because the Constitution is not talking to the states, and therefore the states are free to make their own constitution and decide at which point do we allow or even give the right to the citizens of our state to have the right of effective assistance of counsel. And therefore you'd have to look to the state constitutions and the state laws to see whether they provide this right or not, because you can't just rely on the Sixth Amendment. So that is if we just look at the Sixth Amendment. But it gets fun. Here's where it gets fun. Because we have the 14th Amendment. People are very familiar with the 14th Amendment for a good reason. The 14th Amendment says, and I'm going to jump a little bit ahead, says the following. No state, so now it's talking to the states directly. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. So no state is allowed to deprive any single person of life, liberty, or property without due process of law. What does that mean, due process of law? So cutting through many pages that have been written about due process of law, simply put, it means that it has to be fair. Okay, let's just make it very simple. It has to be a fair process. If you want to deprive a citizen of your state of life, liberty, or property, it has to be fair. Okay, so everybody understands fairness. Now the question is, well, that's very broad. What does that mean that it has to be fair? And the question really ultimately in these cases were, these opinions that we're going to go through soon, is the assistance of counsel the only thing that makes it fair? Is it not fair to not have an attorney assisting you in a defense for a criminal charge, which is going to deprive you of life and liberty? Certainly will. So this is a situation where you're being charged with something and you're facing jail time. You're facing the deprivation of life and liberty. Is it fair to not have a lawyer? That is the question. And at what point is it not fair? Is it a case-by-case analysis? Let's say you have someone who is completely illiterate and doesn't know the first thing about rules of evidence, opening statements. But then you also have other people, for example, let's say followers of my channel, which are all very intelligent people, have been following trials, understand rules of evidence. They already understand how trials, the process of trials. So maybe that type of person, it would be fair for them to represent themselves. How do we look at it? Is it a case-by-case analysis or not? So this is where we get to Betts versus Brady. All right. Now that's the backdrop. Now we can actually get into the opinion and understand what's going on. What happened in Betts versus Brady? Well, what happened in Betts versus Brady is actually a pretty simple by the facts, which is welcoming. Here, the petitioner was indicted for robbery. So he performed a robbery in the Circuit Court of Carroll County. Well, I shouldn't say he actually performed a robbery. He was indicted for robbery. And it was in the Circuit Court of Carroll County, Maryland. So this was a case that started in the state of Maryland. Due to lack of funds, he was unable to employ counsel. And so informed the judge at his arraignment, he requested that counsel be appointed for him. The judge advised him that this would not be done, as it was not the practice in Carroll County to appoint counsel for indigent defendants, save in prosecutions for murder and rape. So in Maryland, now the judge doesn't say this straight out, but it would seem that this is either written in the Constitution or this was just a procedure that they just had, that they would only appoint counsel for prosecutions involving murder or rape. And since this was just a robbery, the judge said, "I'm sorry, sir. I'm sorry that you don't have the money to afford a lawyer, but you will still have to represent yourself, and you're not getting a lawyer. We do not have to appoint a lawyer for you." And that's what happened. And eventually it made its way up to the United States Supreme Court, and where this decision, this opinion was drafted. And there's some other issues involved with this appeal as well, but that's not the focus of what we're going to be talking about. So, the opinion starts off. The Sixth Amendment of the National Constitution applies only to trials in federal courts. So right away, giving us the basis in which we built this video up, and that the Sixth Amendment only applies to trials in federal court. But what about the 14th Amendment? Does the 14th Amendment essentially say that the Sixth Amendment should also apply to the states? Because it's not due process if you don't have a lawyer. It's not fair. And so this is what the opinion says. Due process of law is secured against invasion by the federal government by the Fifth Amendment. Okay, fifth, that's because it says in the Fifth Amendment the same thing about due process, and is safeguarded against state action in identical words by the 14th. The phrase formulates a concept less rigid and more fluid than those envisaged in other specific and particular provisions of the Bill of Rights. Right? The actual phrases of due process, and that you can't be deprived of life and liberty or property without due process, it's not as strong and rigid as some of the other provisions of the Bill of Rights. So right away, we're sensing a little step back from not being as strong what the 14th Amendment protects. Asserted denial is to be tested by an appraisal of the totality of facts in a given case. So yes, it is a case-by-case analysis. That which may in one setting constitute a denial of fundamental fairness, shocking to the universal sense of justice, may in other circumstances, and in the light of other considerations, fall short of such denial. So, certain cases, it may be shocking to the universal sense of justice to not have a lawyer, but in other cases, not. The petitioner in this instance asks us, in effect, to apply a rule in the enforcement of the Due Process Clause. So that's what the request here was. The request in Betts versus Brady was to say that the 14th Amendment is essentially saying that the Sixth Amendment should be enforced against all of the states. He says the rule to be deduced from our formal decisions is that, in every case, whatever the circumstances, one charged with crime who is unable to obtain counsel must be furnished counsel by the state. And therefore, that's the question that they have to decide, whether does due process require that in every criminal case, whatever the circumstances, doesn't matter whether they're a follower of brother counsel or if they're not, doesn't matter. It always, the question is it always unfair not to have a lawyer? So This is what they say. What do they do in order to answer this question? So this is an interesting way. So how would you analyze to determine, if I would ask you, what would you do to answer this question? Is it fair to have a lawyer or not? Well, how do we answer that type of question? So what they did was they looked through the historical data and they looked through what other states' constitutions say. And then they kind of used what the other states' constitutions said and some historical data about whether a lawyer was always a right to, that you can always have a right for a lawyer no matter what the charge, no matter what the criminal proceeding. That was the question. And they looked through all this history, and that's where eventually this opinion came to the conclusion, the following. This material demonstrates that in the great majority of the states, it has been the considered judgment of the people, the representatives, and their courts that appointment of counsel is not a fundamental right essential to a fair trial. So it's not essential to a fair trial. The states, by and large, at that point, didn't all say in their constitutions that you always have the right to an attorney. On the contrary, the matter has generally been deemed one of legislative policy. In the light of this evidence, we are unable to say that the concept of due process incorporated in the 14th Amendment obligates the states, whatever may be their own views, to furnish counsel in every such case. Every court has power, if it deems proper, to appoint counsel where the course seems to be required in the interest of fairness. So it's not that they're saying, no, it's always fair to not have a lawyer. What they're saying is it has to be determined on a case-by-case basis. And in this case specifically, this is what the judge said. In this case, there was no question of the commission of a robbery. The state's case consisted of evidence identifying the petitioner as the perpetrator. The defense was an alibi. So the defense was that that robbery wasn't performed by me. Everybody agrees that there was a robbery. The question is, was it you or were you somewhere else? The petitioner called and examined witnesses to prove that he was at another place at the time of the commission of the offense. So that's what the defense was. I wasn't there. So he called witnesses to say that he wasn't there. And that's what they testified to. The simple issue was the veracity of the testimony for the state and that for the defendant. And this also, by the way, was a bench trial. So it was in front of a judge. And that was also part of the reason why they felt that it wasn't necessary for, in this case, for it to be fair to have a lawyer. As Judge Bond says, the accused was not helpless, but was a man 43 years old, of ordinary intelligence and ability to take care of his own interests on the trial of that narrow issue. So it was only one narrow issue. This was a man who's 43 years old, has some life experiences. He's ordinary intelligence. He had once before been in criminal court, pleaded guilty to larceny, and served a sentence, and was not wholly unfamiliar with criminal procedure. So this is a person who's been through the criminal procedure before. He understands the process. He understands what goes on, and he's intelligent enough to be able to represent himself when the issue is so narrow. And then, so essentially what this court is doing is exactly applying what they believe the standard is that it's a case-by-case analysis, and the judge gets to make the determination whether it would be fair or not for this person to represent himself. But then he does end off, this judge, the justice that's writing this opinion, he does end off with the following interesting analysis here. So listen to this. To deduce from the Due Process Clause a rule binding upon the states in this matter would be to impose upon them, as Judge Bond points out, a requirement without distinction between criminal charges of different magnitude or in respect of courts of varying jurisdictions. As he says, charges of small crimes tried before justices of the peace and capital charges tried in the higher courts would equally require the appointment of counsel. Presumably, it would be argued that the trials in the traffic court would require it. So here, the justice is saying, well, if we are going to buy the argument that the 14th Amendment is saying that it's really not fair, ever, to not be represented by counsel in any proceeding at all, then where do you draw the line? Even small crimes? Even traffic tickets? You should be able to force the court to appoint you a lawyer to represent you, even in traffic court? Where do you draw the line? If it's not a fair process, if you don't have a lawyer, so then you should always be able to have a lawyer, regardless of how small the charge is. And listen to this, and to top it all off. And indeed, it was said by petitioner's counsel, both below and in this court, that as the 14th Amendment extends the protection of due process to property, as well as to life and liberty. So remember, the due process clause in the 14th Amendment says that no state can deprive any individual of life, liberty, and property. Let's not forget that part. So you can't be deprived of property either without due process. So does that mean that you'd also be able to force the state to provide for you a lawyer if your property is threatened to be taken away in a civil lawsuit? If we hold with the petitioner, logic would require the furnishing of counsel in civil cases involving property. So this justice here is Justice Roberts, is saying that if we are going to buy this, if we're going to buy what you're selling and say that it's just not fair, it's never fair to go into court without having a lawyer, and that's what the 14th Amendment requires of every state, where do you draw the line? Traffic courts need them, small crimes, and even property. Somebody sues you to take away your property. Then you should be able to force the state to appoint a lawyer to represent you in that civil case. That can't be. And therefore, after all this analysis, they reject this argument, and therefore they say the due process clause does not require in every single situation for you to have, that the state provide a lawyer for you. Just doesn't do that. And that's what Betts versus Brady stood for. And this was a 1942 decision. Well, in 1963, that's when Gideon versus Wainwright came out. And a very similar story in Gideon versus Wainwright. Here we have the petitioner, the defendant, was charged in a Florida state court. So this is a Florida, not Maryland. Not that it makes too much of a difference. But this started off in Florida state court with having broken and entered a pool room with intent to commit a misdemeanor. This offense is a felony under Florida law. So he was being charged for a felony. Appearing in court without funds and without a lawyer, petitioner asked the court to appoint counsel for him, whereupon the following colloquy took place. The court, Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case under the laws of the state of Florida. So here we have the laws of the state of Florida. What do they say? They say the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I am sorry, but I will have to deny your request to appoint counsel to defend you in this case. And what did the defendant respond? The defendant responded, the United States Supreme Court says I am entitled to be represented by counsel. So this was the defendant's argument, and it doesn't matter. The judge said, no, you're not getting one. And they had a jury trial. He represented himself, and he was convicted. And, of course, he appealed, and now it got to the United States Supreme Court. So same United States Supreme Court that was in Betts versus Brady. Now we have the United States Supreme Court in Gideon versus Wainwright. The only difference is that in Betts versus Brady, it started off as a Maryland case, and in this case, it was a Florida case. So when the United States Supreme Court took this case up, it ordered the attorneys who were representing both parties to address the following question. And this was the question. Ready? Should this court's holding in Betts versus Brady be reconsidered? So essentially they're saying, should we overrule Betts versus Brady or not? Go ahead, make your greatest arguments, file your briefs, and we're going to decide. We're going to have oral argument also, but then we're going to decide whether we're overruling Betts versus Brady. So in the opinion, this is, let's see which justice this is. This is Justice Black. So Justice Black wrote this opinion, and he brings essentially the analysis that we went through in Betts versus Brady. And this is what he felt about it. Plainly, he goes through some of the analysis and he says, plainly, had the court concluded that appointment of counsel for an indigent criminal defendant was a fundamental right essential to a fair trial, it would have held that the 14th Amendment requires appointment of counsel in a state court, just as the 6th Amendment requires it in federal court. So the same way the 6th Amendment requires it in federal court, so the Betts versus Brady opinion agreed that if we would have found that appointment of counsel for an indigent criminal defendant was a fundamental right essential to a fair trial, then certainly we would have said yes, then it does apply. The Sixth Amendment would apply to the states, but they just didn't find that it was a fundamental right essential to a fair trial. What they clearly said in Betts versus Brady is that it's not always necessary for a fair trial to have counsel, depending on the circumstances, depending how literate and intelligent and life experienced and regularity or knowledge of the criminal procedure this person is. And then the Gideon versus Wainwright essentially goes through a number of cases which also say, basically black and white, that there is a fundamental right which is essential to a fair trial to have the assistance of counsel. So this is what they say. We accept Betts versus Brady's assumption, based as it was on our prior cases, that a provision of the Bill of Rights, which is fundamental and essential to a fair trial, is made obligatory upon the states by the 14th Amendment. We think the court in Betts was wrong, however, in concluding that the 6th Amendment's guarantee of counsel is not one of these fundamental rights. 10 years before Betts versus Brady, this court, after full consideration of all the historical data examined in Betts, had unequivocally declared that the right to the aid of counsel is of this fundamental character. So they're saying, Betts versus Brady, Justice Roberts, why did you ignore all of the cases that were already published before Betts versus Brady, which said clearly that the right to the aid of counsel is of this fundamental character? For example, says the fact is that in deciding as it did, I'm sorry. So they do bring a number of different quotes, and then they say the fact is that in deciding as it did that appointment of counsel is not a fundamental right essential to a fair trial, the court in Betts versus Brady made an abrupt break with its own well-considered precedents. In returning to these old precedents, sounder, we believe, than the new, we but restore constitutional principles established to achieve a fair system of justice. And that it's not enough, it seems, to this Justice Black, that there are some other cases that quite clearly state that it is a fundamental right to a fair trial to have a lawyer with you. The fact that it says that a number of cases that predate Betts versus Brady, he also brings, this is Justice Black, he also brings some analysis, some of his own thoughts about why he believes that it makes sense. So here we go. The government hires lawyers to prosecute, and defendants who have the money hire lawyers to defend. And that in itself, the fact that they do that, that's the strongest indications of the widespread belief that lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to the right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. So that's number one. And then you have the greatest quote that all lawyers love. This is just the best. And maybe that's also why he did it. He's a lawyer. He was a lawyer. And, you got to make sure to show how important your profession is. So listen to this quote. Even the intelligent and educated layman, because let's remember, part of what Betts versus Brady said was that If you have someone who's intelligent, he has life experiences, he's been watching Brother Counsel, he really understands the rules of evidence, so then that type of person will be completely competent to represent himself, right? Depends on the person. That's what Betts versus Brady said. Well, listen to this. You'll love this. Even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with a crime, he is incapable, generally, of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. So, what a wonderful quote saying how important it is, no matter how intelligent you are, and no matter how much you think you know the system. Justice Black is saying you need a lawyer. There's a science to the law, and only lawyers can help you and make sure that you are able, make sure you get defended properly. So, because of this, they overrule Betts versus Brady, and therefore they find that in all criminal cases, in all criminal prosecutions, you are entitled to an attorney. Just like the Sixth Amendment provides that, so too the 14th Amendment is now essentially requiring the states to also provide counsel even if someone cannot afford it, which leaves us with just one question. And all of you already are thinking about it. And that question is the final question that Justice Roberts left us with at the end of his opinion. Let's not forget, he asked a question, essentially. And his question was, but then where do you draw the line? What about traffic tickets? What about very small petty crimes? Is the state required to provide you with counsel? Now, as far as I know, they're not. With traffic tickets, they don't do that. You have to go find your own attorney and pay them. They won't appoint a counsel for traffic tickets. And why not? If we are injecting the Sixth Amendment into all of the states now, what does it say in all criminal prosecutions? Everything. Well, a traffic ticket is a criminal prosecution, isn't it? Well, where do you draw the line? And number two, what about his argument? Again, this is in Betts versus Brady. What about Justice Roberts' argument in property? 14th Amendment said no one is allowed to deprive another person no state is allowed to deprive another person of their property without due process. So, if we are saying that clause is what says that it's not fair to not have a lawyer, well, does that mean that you should be able to require the state to get you an attorney in a civil case? Well, number one, you can say, is that this is really to argue that, just to give an argument, I'm back on that, is that the 14th Amendment says that the state should not deprive a person of their property. Doesn't mean that I, as an individual, cannot sue you for your property. But when it comes to the state taking away property from a certain person, then at least that argument, his argument, should still stand. That if the state wants to take away property from somebody, they should have to provide that person with an attorney. And that's something that Justice Black did not address in his opinion. So that's what I'm leaving all of you with. To give me the answer to those two questions. What about traffic tickets? And what about when the state's trying to take away your property? All right, well, that will be it